Good afternoon, everybody. Looks like everything is getting situated right now. Good afternoon, everybody. I hope everyone's having a good Thursday. Thanks for joining if you're on live. If not, hope you're watching the recording later. Happy Estate Planning Awareness Week. My name is Heather Ward. I'm one of our attorneys here at the Legacy Legal Team, and so today I'm kind of just here to chat with you about some scary things that I found out with some estate planning statistics recently, and then also answer some of the most common questions that I get at my estate planning consults, and then of course answer any questions that anybody has during this live. So again, thanks for joining if you're here. My name is Heather Ward, and I primarily practice estate planning, so this I found out pretty early on was my passion, the area that I wanted to focus on. So this is pretty much all that I do, with a little bit of business law and some smaller things here or there. But like I said, I kind of want to get started with some what I think are scary statistics as somebody that practices in this area as far as estate planning. So according to Cambridge Trust, 52% of people don't know where their family member's estate plan is. So, you know, an estate plan can only do so much if people don't know about it. You know, as far as a trust, but it's a little bit easier because you kind of have assets that are in the name of the trust that you're able to kind of find out that there was a trust. But if you don't know where the trust agreement is, if you don't know where the person's will or their power of attorneys are, they're not really doing a whole lot of good. So, tip number one: make sure that you know where your loved ones know where your estate plan is. You don't necessarily have to tell them what's in it. You don't have to tell them what documents you've prepared. A lot of the time, what I recommend if I have a client who's not wanting to be, fully transparent with their loved ones, is say, you know what, tell them that if something happens to me, call my attorney and give them my business card. That kind of, puts them on notice that something is in place, and generally I will know where that original is with our office. The original is usually in our office, so I'm able to provide that in a situation where that is needed. So, tip number one, make sure people know where your estate plan is, including yourself, because I have clients that are like, I had a will that I signed 20 years ago and I've lost it. Not great. Another really big one that kind of hit a little closer to home as a young professional is that 42% of people who earn between $40,000 and $80,000 say they don't have time to write a will, which sounds like a really specific statistic. I don't really know where that came from. But on top of that, it says 32% of those people say that they actually don't have enough assets in order to create an estate plan. And I'm here to tell you, it doesn't matter what you have. I don't own a home, but I still need an estate plan. I have bank accounts. I have a pet that is like my child. I want to make sure she's provided for if something happens to me. But not even, estate planning is not just talking about assets. It's talking about your wishes for both upon your death and during lifetime if you become incapacitated. So, a lot of people, they just think of estate planning, they think of a will, they think of who's going to get my stuff when I die. To me, what's even more important is what's going to happen to you if something traumatic happens. Say you develop dementia, you have a traumatic brain injury from a car accident, anything like that. So, even if you don't have assets, say you basically are living paycheck to paycheck, so you don't really have a whole lot in your bank accounts, no savings, don't own a house. Say you're somewhere where public transit's a thing, so you don't have a car. So you truly have no assets that you need to worry about. You still should have an estate plan. And those main documents that you would still need are a durable power of attorney, healthcare surrogate, and a living will. Your power of attorney is going to name somebody that can handle your business for you if something happens. So for example, you don't own a home, so you're renting likely. You're going to need somebody who can handle your lease on your behalf if you're no longer able to live in a home by yourself. You're going to need somebody that's going to make your medical decisions for you. That may not be for you who is going to be the first in line according to the law. So, if you're not married, it's usually your parents or your next closest blood relative. You may not want that person making medical decisions for you. You know, for me, I'm engaged, I'm not married, but maybe I want my fiance to be the first person and learn to make medical decisions for me. And then obviously kind of in hand with that is a living will. That's, you know, deciding your end of life wishes. I do or I don't want life support, artificial nutrition, hydration, ventilators, all of that stuff. So even if you don't have a single asset that truly needs to be planned for, you can still benefit from an estate plan. 32% of people in America have an estate plan. Only 32%. And you know, I think a lot of it is this misconception that only the uber wealthy need estate plans. Only the people that have a difficult asset list need estate plans. Only people that have minor children need estate plans. And yes, of course, the more factors like that you have, the more likely you really should have an estate plan, but truly everybody can benefit from one. You know, college students, young professionals, you know, middle-aged people whose kids have flown the nest, but they still maybe don't want them to get things out right. Like, there's a lot of different reasons and a lot of different people that really can benefit from an estate plan. You know, one of the biggest questions that I get when people come in for a consult is, I just want a will. Can you do just a will for me? And I think the reason why a lot of people ask for a will is because that's really the one thing that everybody knows about. It's the thing you hear about on TV shows. You read about it in books. You know somebody that posted about it on Facebook. Wills can be great, but to me, especially in Florida, and of course, obviously, I'm talking in the scope of this all being within Florida, but a will is probably the least important estate planning document that you can have, in my opinion. And that's because most of the time when you do planning with me, I actually want to avoid probate, which is the court process where if you have a will, they'll look at the will, say, yes, this is a valid will, this is who your things are to go to. Or if you don't have a will, they look at what's called the intestate laws that say, per the Florida laws, this is who is to receive your property upon your death. The thing about a will is we still have to go through that process. Why go through it if we can avoid it? Probate is timely and costly. It can typically take up to 2 years, even if it's not contested, and will cost about 6% of the value of your assets that have to go through probate. Generally, there's some things that can reduce it or increase it, but that's like the rule of thumb that I like to tell people. So again, a will, we still have to go through that process. That's a really big misconception people that have, is that if you have a will, it avoids it. So for me, you know, if you're doing the normal thing, you want your spouse or your kids to have your assets when you pass away, a will's not really doing a whole lot for you. Now, if you want to disinherit people, then yeah, sure, a will can be great. But there's other ways that we can do estate planning for you where we avoid a probate in Florida. We can do trusts, we can do enhanced life estate deeds, there's, you know, beneficiary designations, all these other things that we can do. So for me, a will is the least important thing you can do. I still, of course, do one for every client that works with me. That's the benefit of the package pricing that we do here, is you're kind of paying for all of the important documents, and then I throw a will in for free. It's kind of how I see it. So again, don't really recommend doing just a will because it's not really doing what you think it's going to do. Another thing that I see happen often, and that I get questioned about a lot, and actually, you know, this week was brought up in a consult, was somebody who has a minor child. And they say, I'm just going to leave everything to so-and-so. I trust them. They're going to take care of the money, take care of my kid. That's the end of it. You know, as a human being, I understand. Obviously, I love that you've thought about it and you have somebody in your life that you trust to handle the finances for a minor child. As a lawyer, I hate that because that person has no legal requirement to use that money to take care of your kid. Instead, we like to do trust when there's minor children involved because there is somewhere for all the money to go and specific rules that must be followed, but then you're able to name somebody that will be responsible according to those instructions you've provided. And there's some recourse if they don't follow the rules. Of course, whoever you've named, you already trust to make that decision, but I'm a lawyer. I see the worst thing happen all the time. People go crazy when people die and there's money involved. It's not always the case, but you would be shocked how often we see it. And then, you know, the last real big question that I get as far as estate planning is, do I need a trust? I am not one of those lawyers that will sell you on a trust if I don't think you need one. In some states, a trust is the only way to avoid a probate. Of course, like I said, that's usually one of my biggest goals with doing estate planning for a client is let's keep you out of probate. Not everybody needs a trust, you know. In your meeting with your consultation with your attorney, we'll kind of walk through, you know, who are we planning for? What are your concerns? What are your goals? And for some people, a trust still does make the most sense. You know, if you're wanting to put a bunch of rules, if you're wanting to put age restrictions, what the money can be used for, those are types of reasons why sometimes we go to a trust. Also, you know, if you have a child that you're wanting to leave everything to, but they have some health issues, so you're kind of worried about them, you know, God forbid, dying before you. So then we need to plan for the backup beneficiaries, like your grandkids. That's a really big reason that people like to go the trust route, is because then we can put in extra protections to make sure things go to the grandkids, or another alternate beneficiary that I can't do with a lot of other types of planning that would still keep us out of probate. So again, for some people, a trust is a great option, but not everybody needs one. We do have other routes that we can take to keep us out of probate in Florida, which again is a real big deal. It saves a lot of time and a lot of money for the people that come after you. And you know, like I like to say, you're kind of doing a service for them without even realizing it, because you're just making things a lot easier for the people that come behind you. So that was kind of just my little spiel I wanted to give. It's Estate Planning Awareness Week, so you know, I deal with this all day, every day. There's a lot of common questions that pop up. I'm going to stay on for a little bit longer and see if there's any additional questions that people are going to ask. But of course, take everything that I say as general advice under Florida law. If you have anything specific that you want to talk about, give us a call. We'll get you scheduled for a consultation and talk through what it would be for you and your family specifically. Okay, the first question is always about price. The first question is the cost comparison to get an estate plan done now versus a probate. And that's kind of a hard question to ask, because it's going to, or a hard question to answer, because it's going to depend on what you have and what attorney you're working with and what your plan ends up consisting of. You know, like I said, at our firm, we typically do everything as a package. So we set you up at minimum with a will, your power of attorney, healthcare, living will, all of those documents that you'll need. Sometimes we add on a ladybird deed, sometimes we add a trust onto that. You're looking at least $750 if we're doing just the deed, or we're looking at $5,000 for a trust. Like, it's all going to depend on what you need and all that stuff. Also, it's going to depend for your probate costs. Sometimes we can get away with called a summary administration, where it's not like a full probate, and it all depends on what type of assets, how long the person has been gone, those types of things. I do not practice in that area anymore, so I don't even know what we charge there, but I can tell you, if we're doing a full probate where, you know, we've got a lot of things to deal with, we've got to send out all the notices to creditors, do all of the things, what we usually say the ballpark is going to be about 6% of the value of whatever assets you have. So say you have a $200,000 condo. That's all we're dealing with in Florida. I'm doing the math right now on my phone because I'm not a math person. $12,000 for that probate. About 6% between personal representative fees, court costs, all of the things. You're looking at about $12,000 versus a few $1,000s at most, generally. So there's a big price difference there. Another question is, do you recommend having your attorney hold on to the original estate plan documents instead of the individual? The way that I recommend it in our office specifically, and I think the reason why I feel even more comfortable is because, like, we used to be a bank, so we have a big vault that we keep all of our originals in. I prefer to keep the originals at the office for safekeeping, and there's a few different reasons for that. One, I've had a client in the past who had their documents in their house and their house burned down, and they no longer had those documents. Some people keep things in their safety deposit box, but then they don't have anybody else named on that safety deposit box that we can't access until we go through a probate. So, like, there's a lot of reasons to not have your originals, mainly just for safekeeping. Another big reason why I like to keep originals at our office is because of the way that we do our durable power of attorney. In Florida, we don't have what's called a springing power of attorney, which means it would go into place when the person becomes incapacitated. In Florida, it's valid as soon as you sign it. So a lot of people are very hesitant about that because my power of attorney is pretty long. It's about 20 pages long, covers basically everything under the sun. And the reason why I do that is to avoid guardianship. So there is a reason why it's so specific and so broad at the same time. That's very scary. You're signing your life away to somebody that hopefully you trust, but again, people go off the walls. They could go sell your house out from under you. They could wipe out your bank accounts. They could do all of these awful, terrible things. So the way that I do my power of attorney is the person, in order to use it, has to have the original in hand. So we keep the original at our office, and an attorney signs off before that original can be released to the agent. That way there's kind of a little bit of a check and balance. It's not a perfect system, but it's the best that we've come up with of how to stay in the Florida law and then also protect our clients. But again, I do still have some clients that prefer to take their own originals for whatever reason. Maybe, I truly don't know why some people do, but they do. And there's nothing wrong with that. We're happy to do that as well. Kind of on that note, I've had clients ask me whether they can make two originals so that there's an original with us and an original with them, and you can't do that. We provide copies to you, and we can provide attested copies if that's ever needed, but we only do one set of originals. Can you put limitations on what power people have? So I don't know if you're asking in the context of a power of attorney. Yes, we can limit the power of attorney. You don't have to include everything in it. The reason why I like to include so many powers in that document is to avoid guardianship, which is the court process where if you become incapacitated, you're examined by 3 medical professionals that say yes, they can no longer take care of themselves, make their own decisions, those types of things. If we have a power of attorney that addresses a particular circumstance, the court actually has to allow that power of attorney to stand before going for guardianship. So if it's addressed in your power of attorney, we can avoid at least a $6,000 process of having a guardian appointed by a court. Some people want to take that risk and say, you know what, if that happens, then at least the court's supervising something. Cool, perfect. I will advise you about why I think that's a bad idea. We'll go through specifics of your power of attorney. And if you want to take stuff out, we will. I have had clients where they start removing so many things that I'm like, you know what? We're just not going to do one of these. You're clearly not comfortable. And then I, of course, explain to them what that could mean for them in the future. But it's your choice. If you have an attorney that is pushing you to do something that you are not comfortable with, run. Please do not ever work with an attorney who is pushing you to do something that you don't feel comfortable with and don't understand. I spend a lot of time with my clients explaining things, and there are some times where I'm like, please just trust me. I know the alternative, but I will explain it to you. If you still think you don't need it, that's fine. You're going to sign a document saying that I advised you not to, but I still won't force you to do it. How long does the estate planning process take from the first appointment? So again, it's all going to depend on who you work with. At our firm, my goal, if everything's going according to plan, there's nothing crazy happening in my life or at the firm, or client emergencies. I do have some people that come to me from on their deathbed, and they obviously get moved up to the top of the list. My goal is to have you signing from 4 weeks from your appointment. You'll receive your first draft is usually what I aim for, and then of course from there it's going to depend on how many questions you ask, how many changes we need to make based on that first draft. So again, usually my goal is within 6 weeks you're going to be signing, but it all depends on the client and what's going on in your life, and of course how difficult your estate plan is. If we're doing just a will and a power of attorney package, that goes much faster than if we're doing a trust, because there's just a lot more drafting and a lot more questions that are usually asked because it's a much longer document and a lot more documents overall that you need to go through to review. Because I will not let you sign something unless you've read it and we've discussed it a little bit so that I can be sure that you know what it says. I love my clients that trust me, but I need you to kind of know what's going on so that you can explain it to other people if needed. I think that it looks like that's all that came through while we're on here. I'll stay on for just another minute or two, see if there's any other last minute questions that come in. But of course, like I said, at our office right now, we are offering free consultations for estate plans. So there's zero obligation if you decide you want to come in, ask your questions about your own specific plan, what you could benefit from. If you have a plan already and you want me to review it, we do that as well. So make an appointment with an attorney, get this done. I know it's one of those topics nobody wants to think about dying or something traumatic happening. But once you have it done, you kind of have it behind you unless there's some big change in your life, like divorce or death of a family member or having a new child or grandchild. Kind of once it's in place, it's kind of there unless there's a big change in the law or a big change in your life. So I like to tell people, you deal with the uncomfortable for 6 weeks, and then from there you're done and don't have to worry about it again unless something happens. All right, I think that is it. So I will keep a lookout to see if any other comments are posted after this and answer them in the comments if needed. And if not, I hope to hear from some of y'all and get some estate planning done. Have a good rest of your day and enjoy the rest of your week.